Jeff, let's pick up where Nnamdi left off. When we hear the president talk about maybe we could use a softer touch, is that because he cares about how the people are being treated, that is something that's impacted him, or is it about the polls?
Well, it's hard for me to answer that. I can't get into his head on what he's feeling, but I think if you look at the facts and if you look at the sort of the politics of this, it can't not be at least a reaction in part to the polls. And the president is pretty sensitive to that. And his entire administration, of course, is clear that this is an election year, that the midterm elections are coming up in several months, and seeing a decline in popularity for one of the main policy issues that helped him get elected a year and a half ago, or in 2024, is not a strong political place to be going into an election that could change the balance of power in Washington. So, and I think the other question that it raises, which we heard from some of the voices on the ground that you played earlier, is does a tonal change equate a policy change? And you haven't heard the president say that. Saying that he would like to see perhaps a softer touch is not the same as saying, I'm going to rethink my immigration policy. That is not what he's promising. And so I think as we see watch what happens in the coming days and weeks and months, that'll be the question: is does tone mean any sort of change in operations on the ground or in the goals of his immigration policy overall?
And let's talk about the immigration policy piece here. Steve, there's this op-ed from the current DHS general counsel where he claims it's not the deep state, or rather it is, he says, the deep state, not the Fourth Amendment, that keeps ICE from entering homes without a judicial warrant. You and several of your colleagues, all former DHS general counsels, penned a response to that. And let me read part of what you write. Quote, "The job of the general counsel is not to provide convenient legal cover or constitutional workarounds. It is to provide sound legal analysis and advice, even when that advice may be inconvenient for the administration. That is not sabotage. It is upholding the rule of law." Steve, if you were still advising the DHS, what's the first thing you would do to correct the alleged constitutional violations?
Well, thank you, Anna, for focusing on this issue. I think it's a very important one. And I would just like to point out how unusual and remarkable it is that acting general counsels from the Bush, Obama, and Trump 1.0 and Biden administrations all agree on something and are willing to say it publicly. I'm not aware of that ever happening before. If I were there now, I would suggest that the department and the general counsel in particular focus on leveraging the expertise of the professional lawyers that have been working in the department in some instances since its origins, and instead of denigrating them as some sort of treasonous deep state, listen to what they're saying. If there's a reasonable issue that needs to be teed up, that's fine. But don't try to hide behind some sort of conspiracy theory that there's a bunch of people in the government who have an agenda that are trying to subvert what ICE is doing. That is not at all what's going on. And that needs to be fixed before anything else can move forward in a legal and reasonable way. And by the way, one of the people I worked with when I was there was Tom Homan. And I remember him explaining that ICE does not have the ability to go into somebody's house without a judicial warrant. So this is not a new issue.
Can you explain the difference between judicial warrants and these administrative warrants the DHS general counsel cites as justification for what it's doing right now? Does any of it hold up?
Well, there's some nuances, in all fairness, but the basic principle here is that if the government, law enforcement, wants to come into your house and literally kick down your door to come in and arrest you, you need an arrest warrant from a judge. That's true when the FBI is going in to arrest a suspect for murder. What's happening here is that ICE is taking the position that they can basically sign their own arrest warrants and kick in a door and go arrest somebody for a civil immigration violation. So that at a kind of constitutional level is what's at stake. An administrative warrant is not the same thing as an immigration judge's order of removal. That's basically a court order saying you're going to have to leave. It doesn't necessarily say when, and there's some intermediary steps that often have to be satisfied. It doesn't make you a fugitive. So there's some nuance here, but the bottom line is that an administrative warrant is essentially like having the police sign their own arrest warrants, and that's un-American.
Steve, you've also worked in the U.S. Attorney's Office, so I want to ask you about this government lawyer, Julie Lee, who reportedly was removed from her post after telling a judge, and I quote, "This job sucks." She says it takes 10 emails to get anything done. She's been assigned 88 cases in less than a month. 88 cases. What do you make of the workload and the reaction, just all of it?
Well, 88 sounds like a lot. You're not going to get quality legal representation if you totally overwhelm the lawyers that are representing the United States. They have a huge shortage of personnel, and this is a reflection of it. And frankly, it's aggravated by the point I made earlier about if you denigrate the career professional staff by calling them incompetent or, members of the deep state, you demoralize them. Of course, the job sucks because you're not getting any appreciation for what you're trying to do in good faith. So I think it's all part of a larger problem that is, frankly, of their own making.